Good afternoon and welcome to the Caregiver Coalition of San Diego Caregiver Webinar. My name is Matthew Parcasio. I am the Caregiver Programs and Outreach Coordinator at Aging and Independent Services Department of the County of San Diego Health and Human Services Agency. I will be your host on behalf of Caregiver Coalition of San Diego that represents the community efforts, a diverse group of agencies, private, public, professional, nonprofit, and those supporting family caregivers. I'll be your host for today's webinar. Our collective mission at the Caregiver Coalition is one of support, education, and advocacy. I'm recording today's webinar for future viewing. All past webinars can be found on our website and our YouTube page at caregivercoalitionsd.org. But thank you so much for joining us today. We're so glad to have attorney David Schwartz, who will talk about basic planning documents and powers of attorney, advanced healthcare directives, and wills. There'll be a little bit of time for question and answer at the end of the webinar. So if you have questions, please put your question in the chat. So then right when we end, we can get your question answered as best we can. And if you can kindly put yourselves on mute so that we can assure that David's webinar goes very smoothly without much background noise. David Schwartz is a staff and attorney with Elder Law and Advocacy and has been a nonprofit law at the nonprofit law firm for over 15 years, serving seniors in San Diego County and Imperial County. Now it's my pleasure to welcome David.
Thank you, Matthew, and thank you all for joining me here today, and anybody who's watching this recording in the future. So you're not going to see me for too long. What I'd like to do is I'm going to share my screen. We tested that out, and hopefully that works. And you're going to see a PowerPoint presentation. Right. So you should be seeing our giant orangey Elder Law and Advocacy logo now, and the title. I'm guessing Matthew would have told me if there was a problem, so we're going to march ahead.
You're good.
Thank you. Okay.
Thank you.
So topics today, we're going to talk about what collectively I would call planning documents, kind of basic planning documents. I do think these are documents that everyone should have, not just seniors. Everybody of any age should have these documents. They're not mandatory. They're not required. I just think they're good things to have. The planning documents we're going to talk about today are Advanced Healthcare Directive, Power of Attorney, and Will. Before we get, how do we get to the next page here? Sorry about this. There we go. I know transitions fell out of favor and they're cheesy, but I love them. So a quick disclaimer that we're a law firm, so of course there's a disclaimer. I'm just going to speed through that, and a thrilling funding note, because we should put that on all our presentations. Our funding comes from state and federal agencies and the State Bar Association. So to start off, a quick overview on these three planning documents, just as basic as I could, explaining, starting with the Advanced Healthcare Directive, what it does. During your lifetime, it gives a person who you choose authority to make medical decisions about you. The power of attorney, very similar. During your lifetime, it gives a person you choose authority to make financial decisions for you about your money, your property, your income, but only for your benefit. With a will, I think most people already know what a will is, but to be clear, a will doesn't do anything while you're alive. It is only something that takes effect after you pass away. It directs how whatever still belongs to you after you've passed is to be distributed to your beneficiaries. So we're going to start, I grouped together Advanced Healthcare Directives and Powers of Attorney because they're very similar. They're structured very similarly. They do different things, but in a very similar way. So I started this kind of as a question. Who has legal authority to make medical and financial decisions for me if I have dementia and can no longer make my own decisions? And the answer is Nobody. At least that's the short answer. And my asterisk there, it's nobody unless before you became incapacitated, you granted someone decision-making authority through an advance healthcare directive and a power of attorney. To be clear, family members do not automatically have authority to make decisions on behalf of other incapacitated family members. A child does not have any kind of legal authority to make decisions on behalf of a parent. A spouse does not have automatic decision-making authority over another spouse. Without a power of attorney or an advance healthcare directive, or in kind of a worst case scenario that we're just going to barely touch on, unless there's a conservatorship, nobody but you can make decisions for you, whether they're medical or financial. So talking about advanced healthcare directives, I only use the term advanced healthcare directives. I'm not going to say that's the correct term. That's just the term I use. You may have heard what I call an advanced healthcare directive referred to as a power of attorney for healthcare, medical power of attorney, healthcare power of attorney. I use the abbreviation AHCD. Living will is the only one I've definitely heard used to refer to an advanced healthcare directive. I would argue that's not really correct. That's not what living wills are, but sometimes people do use that term. 5 wishes, I've forgotten which medical service provider does, but they publish their own, maybe Sharp or Scripps, they publish their own advanced healthcare directive under the moniker 5 wishes. It's an advanced healthcare directive. It's a fine advanced healthcare directive. I just want to make clear that's an advanced healthcare directive. It's going by another name, but that's exactly what it is. I have had plenty of clients refer to an advanced healthcare directive as that thing I signed before my last surgery, because medical professionals absolutely want you to have one of these things, especially before, for example, going under the knife. So powers of attorney don't really have so many other monikers. Their power of attorney is a power of attorney. POA, the acronym. That other thing I signed before my last surgery, because they're often prepared alongside an advanced healthcare directive, though they absolutely do not have to be. Moving on, getting into a little bit more detail. So for an advanced healthcare directive, the key legal terms here are the principal and the agent. The principal is the person who's creating the advanced healthcare directive. The person who is choosing some other person, an agent, to make decisions on behalf of the principal. Generally speaking, it's going to be set up as springing. I'm not saying that's a correct decision. That's just what I see more commonly. Just to go further down on my slide to define, an advanced healthcare directive, and we're going to see in a minute powers of attorney, they can be either immediate or springing. Immediate is what it sounds like. The principal creates an advanced healthcare directive or power of attorney and names an agent and says that that agent's authority is effective immediately. That's the immediate choice. As soon as the document is signed, the agent has authority to make those medical or financial decisions. If the principal chooses to make their advanced healthcare directive or power of attorney springing, what that means is nobody but the principal has authority to make decisions on behalf of the principal until and unless doctors determine that the principal has become incapacitated. There isn't a legal standard, but I'm just going to say it. 99.9% of the documents I've seen, the determination of whether a person is incapacitated is established by 2 separate physicians. 2 separate doctors have to agree that the principal can't make their own decisions. It is worth noting, whether the document is immediate or springing, the principal under the advanced healthcare directive or power of attorney does not lose their own decision-making authority. You only lose your decision-making authority if you've become incapacitated, if you can no longer understand your own long-term decisions. So I've got another slide here that is really just telling you the same thing, because for a power of attorney, the setup is exactly the same. you've got the principal, you've got the agent, you've got immediate, you've got springing, all very much the same. It's just dealing with a different subject. The Advanced Healthcare Directive deals with medical decisions. Power of attorney deals with financial decisions. So to get into a little bit more detail, so on the Advanced Healthcare Directive side, the Advanced Healthcare Directive itself, so the authority of the agent ends when the principal passes away, or earlier if the principal decides to revoke the Advanced Healthcare Directive. As long as the principal has capacity, that is an option the principal has. When you make an Advanced Healthcare Directive, as long as you still have capacity, you can make changes to it, or you can revoke it outright. There is an asterisk, so I'm going to jump down to the asterisk. So the Advanced Healthcare Directive, it ends when the principal passes away, with 3 exceptions, and they're not particularly common to come up. Well, I suppose anatomical gifts is plenty common, because whether there are anatomical gifts or not, that's still a decision that the agent can make, and can only make, after the principal has passed away. You don't get to donate somebody else's lungs while they're still breathing. Authorizing an autopsy is another thing that the agent can still do after the principal has passed away. Authorizing an autopsy hopefully would not be necessary. In most cases, autopsy is only going to come up if there's a suspicious death. And then the term that you would normally see on an Advanced Healthcare Directive is direct disposition of remains. To be clear, I always phrase it like this. This in California means authorizing whatever, usually hospital typically, is in possession of the principal's remains. The agent can authorize that hospital to release the remains to a licensed funeral home. It does not mean that the agent can take the remains home themselves in the passenger seat of their car. And actually in California, human remains are hazardous waste. There are a lot of restrictions on that. So it's just dealing with basically signing paperwork to let a hospital release remains to a funeral home. So I will jump back up so that in that middle section on the slide you're looking at, the agent does have a duty to the principal to make medical decisions in accordance with the principal's wishes. It's only in the event where the principal's wishes are unknown that the agent can essentially try and guess and decide what the principal would have wanted or what is in the principal's best interest. So for powers of attorney, much simpler. Power of attorney just stops having any effect when the principal passes away, because it's not a will. It doesn't deal with giving property to anyone. And I see I have made a mistake here. It should say the agent's authority ends when the principal dies, parentheses, no exceptions, or when the principal revokes the power of attorney. So my mistake there. That should read power of attorney. And the next statement, it's in bold, and I'm going to repeat it for emphasis. The agent has a fiduciary duty to the principal to use the principal's property and income only for the benefit of the principal. It is worth stressing a power of attorney is not about giving property to anyone. It is allowing someone else to use your property only for your benefit, not for their benefit, not for anyone else's. It's just authorizing someone else to manage your finances for you, not gifting anything to anyone. So if so Advanced Healthcare Directives and powers of attorney do not have to have an attorney involved in the drafting or at any stage. Elder law and advocacy, we do draft plenty of Advanced Healthcare Directives and powers of attorney, and I won't speak for the other attorneys, but for myself, I am very happy to do that. I love it. It's one of very few instances where somebody's coming to an attorney where they don't have a problem, and they're taking positive action to get it to avoid problems in the future. So I definitely like doing those, but my involvement or any attorney's involvement is not required. The only thing that someone needs to do to create an Advanced Healthcare Directive is to complete it. You identify yourself as the principal, you identify your agent, you identify whether you want it to be immediate or springing. There's not a single advanced healthcare directive form, but typically there will be additional optional sections where you can make decisions in advance about how you would want your medical care handled. And then executing the document means signing it for an advanced healthcare directive, signing it either with a notary or with two witnesses. And then California has a special rule that at least one of the witnesses can't be related to you. For a power of attorney, everything I said about advanced healthcare directives, it's the same for power of attorney, except you don't want to sign it with two witnesses for practical reasons. Technically, it would be legal to sign a power of attorney with two witnesses under California law. That is validly executed, but banks very often just won't honor a power of attorney that doesn't have a notary stamp on it. So for practical reasons, you want to get a power of attorney notarized. So I'm going to skim over this, but just to quickly distinguish, we talked about conservatorship up top. So conservatorship is a court process. Generally speaking, it's what somebody who doesn't have a power of attorney or advanced healthcare directive and becomes incapacitated, it's what they need so that some other person, the conservator, can make decisions on behalf of the person who has become incapacitated, who didn't have these planning documents. So moving on to wills. I'm going to define it. I'm going to kind of summarize it, but again, I do think most people have a pretty good idea of what wills are. So the testator is the term for the person who's creating the will. The estate, and this is important to define, your estate is what you still own after you pass away. That's your estate. And then we're going to talk in a slide or two about ways that you can manage your estate so that you don't have a very large estate for the purposes of avoiding probate. Executor, again, I'm going to emphasize a will is just a piece of paper. It does not do anything while you're alive. Your executor, whoever you've named as executor on your will, has no authority to do anything during your lifetime. It is strictly somebody that you're nominating so that after you've passed, a judge can appoint them in a probate proceeding to act on behalf of your estate. And even then, the executor does not have discretion. They can't choose to give what to whom. They have to follow what you've put in your will. And then just a quick definition. So probate is the court process during which a judge oversees the distribution of an estate to the beneficiaries of the person who's passed away. Can be distribution according to a will, also could be according to California's intestate rules if someone dies without a will, and that's all intestate means. It means without a will. So I'm going to emphasize, I don't want to read the whole slide to you, but I am going to emphasize the testator chooses who their beneficiaries are and what anybody will get. No one is entitled to get anything from anyone. No one is entitled to get anything from you. There's no one you have to give property to. I will mention that typically if you're going to leave out a very close relative, a spouse or a child, you want to specifically mention that person by name and call out, yes, I recognize this person and their relationship to me, and I'm not giving them anything. It is also important to mention, we're going to get into probate more, but on this slide, it states the testators will determine who receives what from their estate, whether or not probate is required. Wills, having a will or not having a will does not change whether or not probate is required. And then we talked about execution, completing a document, signing with two witnesses or signing with a notary for advanced healthcare directives and for powers of attorney. So wills are the opposite of power of attorney. In California, a will has to be signed with two witnesses. A notary is not only not required, it doesn't do anything. If you did have a notary to come and notarize your will, that's not enough. That's not what California wants. So talking about probate, the probate process. And honestly, I don't believe I have it as a slide, so I'm going to talk about it, even though it's not on your screen right now. So what does define whether formal probate is necessary, whether your your beneficiaries would have to go to court to have your estate be distributed, is based on the size of your estate, how much money or the value, I should say, of the property in your estate determines whether or not your estate goes through probate. It's not a fixed number. Just since I became an attorney, it's changed a couple of times. Last time I checked, and I probably should have checked this and put it on a slide, but didn't. It's a hair. It's not a nice round number. It's a hair, I think, over $166,000. That is the value of everything combined. If everything in your estate is under that, then your beneficiaries would not have to go through the probate process. They don't have to bring the matter to court. Judges don't have to get involved. Lawyers don't have to get involved. It is still an option. It is just not required. It can be handled through the small estate process. The probate process, if your beneficiaries do need to go through that, it can be very lengthy, even if there's no disputes, even if things are going well. I like to tell folks it's not the end of the world, but it's nice to avoid if you can. So probate starts where somebody, usually a beneficiary or an executor, if there's an executor named in a will petition for probate to the court. And they get letters of administration that lets the person the court nominates, the court appoints as executor to administer the estate. In other words, pay off any creditors of the estate. So if you die owing money, your creditors still can get paid from your estate, and then whatever money is left, that gets distributed to the deceased person's beneficiaries. There is a requirement in California, and as far as I know in every other state, that there's a publication of notice of the hearing in a newspaper of record, which is, I think, a bit antiquated and expensive, and the newspapers know that. Some newspapers, I think that by itself is keeping them alive. There does need to be notice given to all the decedent's relatives, even if they're not getting anything. The person petitioning the court for probate does have to collect information about all the assets, essentially do an accounting of the estate. And then administering the estate means going through what I've talked about, paying off debts, including debts to Uncle Sam, so all your taxes, even after you're dead, still got to pay taxes, and then ultimately distributing whatever your estate is to whoever your beneficiaries are, and the estate is closed. So I mentioned kind of suggestions I have, so as far as keeping the size of your own estate small. Oh, I did have the dollar amount, and I mentioned the dollar amount has changed. That second category there, I said 166,000. That's an old number. Forget I said that. Right now, whether or not your estate needs to pass through probate is if the total is 184,500 or less. There is a separate rule for real property, but we're in Southern California. I don't think you're ever going to find real property that's worth less than $61,500. I think I would imagine even undeveloped land is probably going to be more expensive than that. But so I do talk a lot about designating beneficiaries on financial accounts. It's generally speaking a good idea. It's not a legal process. It's just something you would work with your financial institution, whether that's a bank, that's a credit union, that's a retirement system. You can designate a beneficiary, and the point of that is the money in that account doesn't belong to you anymore after you pass. Once you pass away, the money automatically becomes property of whoever you've named as your beneficiary. So it doesn't become part of your estate. It's not going to help push the total value of your estate up to and above that $184,500 amount that triggers probate. If you do own real property, I touched on that earlier, we're in Southern California. Real property is very, very valuable. What you can do, and there are some potential drawbacks. I frankly don't see the drawbacks as being that much of a problem, but there's what's called a transfer on death deed that you can record at the county recorder's office, obviously before you pass away. Essentially, you are deeding the property to whoever you want to gift that property to. It can be one person, it can be multiple people. But that deed does not take effect until and unless you pass away and still own that property. If you sold it during your lifetime, that's fine. The transfer on death deed's there, it just doesn't do anything. But if you do still own the home, it stops being yours the moment you pass away. It becomes the property of whoever you named on that transfer on death deed. I'm going to skim over the spousal or domestic partner property petition just because it's still probate. It's just a kind of shortened version of probate. It works, but it's not necessarily all that much better than property passing through probate, the full probate process. So there's a lot of text here, and I'm going to leave this slide up for as long as I can, but I don't want to get too far into trust because I think I'm getting close to our time limit, and I do want to leave time for questions. Trusts are not wills. Wills are not trusts. They are different things. Trusts are great, but they're expensive. Trusts can do more than wills can. But like I said, the drawback for a trust really is just the cost. It's worth noting just that first bullet point there. A trust creates a new legal entity. That's not something a will does. With a trust, it's creating, like, that trust is like a person or like a corporation. It's its own thing. It's not you. It's not something that you own. In fact, usually what you do when you create a trust is give most, if not all, of your property to that trust. You control it, but that's different than owning it. And then, you can sit there. It's hard to talk in too much detail about what a trust can do because it's almost limitless. You can set up a trust to do almost anything. That said, most of the time people set up trusts to do basically what a will would do. The advantage of a trust is because the trust is a separate entity. If a trust owns all your property, then what you own when you pass is going to be very little, if not nothing. And so your estate is going to be very, very small. It's not going to require probate. The trust will essentially get through distributing property after you've passed without the probate process being necessary for any of your beneficiaries. That's the main advantage to a trust. So I believe that's the last slide. Last slide just on what elder law and advocacy can and can't do for you. For advanced healthcare directives and powers of attorney, we'll look at them. If you've got them and you have questions or just wanted help reviewing them, we can draft them for you. We can execute an advanced healthcare directive for you, which just means we can be two of the witnesses, the only two witnesses you would need. With a power of attorney, we don't have a notary on staff, so we can do everything but execute that. So we can get it prepared, and then you'd have to take it to any notary, because any notary stamp is as good as any others. With wills or trusts, we can review them, we can advise on them, but we do not draft wills or trusts. And then, of course, along with that, we don't execute wills or trusts. So with that, a picture of a great horned owl that took up residence for a short while, literally 4 feet from our front door. And so who has any questions?
David, thank you so much for that information. I know it's a very short time. We could probably spend way more time talking about this, as it sounds like with the attendance today, such an interest in your topic for this afternoon. But since we have a short time, we do have a couple questions. One from Zadie is a trust necessary to be completed for each property in the prospective states?
I can answer that pretty quickly. So no would be the short answer. because the United States are united, it's the full faith and credit clause. The short answer is it's not necessary. When you create a trust, you say this trust is created under such and such state's laws, and such state's laws apply. That will work whether the trust owns things in that state or in any other state.
Thank you, David. The next question actually was for me. You mentioned that you can do a transfer of deed for a property before you pass away at the county. Do you suggest that before we pass away, we own a property, that the transfer of deed should be recorded there, and should we still have a living trust as well too?
So the transfer on death deed is a good idea. That's kind of my estate planning on the cheap, because I love doing things cheaply. If you had a trust, the transfer on death deed would not be necessary. The benefit that you get from that is you already have, because you've got the trust. You're presumably going to avoid probate, because that property you would transfer it to the trust rather than create a transfer on death deed.
Great. Thank you very much. Another question from Tracy is, if you select immediate for your advanced healthcare directive that assumes the principal would still be making decisions for their care, but their agent may also be able to make decisions without having two doctors say that you are incapacitated?
Yes, I mean, I don't think there's a question there, but that is a correct statement. That is accurate, yes.
Great. And Nadia asks, how often do trusts need to be updated?
There is not a rule on that, just kind of like rules of thumb. It's a good idea to look at that every 5 years, every 10 years, or if there's a major life event. If somebody gets married or somebody gets divorced, you definitely want to update all your planning documents. Sad, but death of a child, that's a major life event. It's something you would probably want to update. When your head has cleared, you don't want to make planning documents when you're emotionally hot.
Thank you, David. The next question is a power of attorney notarized in California effective in other states?
Yes, absolutely. Again, going back to the full faith and credit clause. So if it's valid in California, it's valid in any other U.S. state, and vice versa. If we see a Virginia power of attorney that was validly executed in Virginia at the time, even if it doesn't meet California law's standards, as long as it was valid in Virginia at the time, it's valid in California.
And a similar question that I have along those lines, if you're coming from another state and have a power of attorney, an advanced healthcare directive created there, move to California, would you just need the advanced healthcare directive transferred onto a California version of the advanced healthcare directive?
You would not need to. It's not a bad idea to. I would recommend it, but it's not a requirement for the same way I was talking about the power of attorney. Same would apply for an advanced healthcare directive. It's a good idea to update, but it's not mandatory.
Thank you. The last question is, if both husband and wife are on the house deed and one passes away, does the other automatically have control of the property, or is a death deed or a trust needed for the other partner?
So it does depend how the property is held, because even when you've got joint ownership, there are different kinds of joint ownership. That said, it's practically a given that spouses are going to own property as joint tenants, meaning that if one passes, the surviving one automatically absorbs that ownership share. So basically you would know if it wasn't held that way. You would have had to take specific action to not purchase property as joint tenants with that right of survivorship. So it's not necessary. Still, it's not a bad idea, but it's not a requirement.
Great. Well, thank you so much, everyone. There's been such great questions. David, would you be so kind as if any family caregivers that are on the call today or any individuals caring for older adults had any further questions for you, any legal guidance, would you be able to share your email address in the chat or phone number contact at Elder Law and Advocacy so they can reach you?
Absolutely. I'm going to put the Elder Law and Advocacy phone number up first. And then should anyone need it, that's my email address. We would want anybody we're giving legal advice to go through our whole intake process, but I normally tell folks who go to presentations I give, if you mention that you were part of the presentation, I'm normally happy to skip that. If I can give quick advice, answer a quick question, that's fine. I'm happy to do that.
David, thank you so much for your time today. And thank you to all of you for joining us at the monthly Caregiver Coalition of San Diego webinar. I hope you found this beneficial. I will stick around if anybody needs to jot down the phone number for Elder Law and Advocacy and Attorney David Schwartz's email address. But otherwise, thank you so much. And we hope to see you again next month. Bye-bye for now. And yes, this is being recorded and will be shared. Thank you. Thank you so much, David. Appreciate your time.
Hi. Is there someone that can respond to my question?
Unfortunately, David's webinar ended already, but in the chat, he put his email address and phone number.
Okay.
So you are definitely.
Yeah, I'm sorry, but this is the first time I've connected. And
Okay.
I was for the majority of this. I got in the last couple minutes. And I'm just wondering if there's something like this is held again, or since I am on the phone, I don't know how I access the information that he just gave in terms of an email. So can you give it to me over the phone, or how did you say I was supposed to?
Oh, you were on the phone. My sincere apologies. That's
Yeah,
right. You are not
yeah.
you are not logged on to Teams, but on the phone. Yes. So let me give you Attorney David Schwartz's phone number. It's 858. I'm sorry. This is his office, which is called Elder Law and Advocacy, that provides free legal assistance to older adults and family caregivers. It's 858 565 1392.
Can you give me 1 second? You said it was elder care. Is that what
Elder Law and Advocacy.
Law and advocacy.
Yes.
Okay. And if this was well attended, do you think there will be another one or anything like this?
That's a great question. You know that we last month the Caregiver Coalition held a webinar on a similar topic on incapacity with another attorney. And that one was so well attended, I decided to keep the kind of similar theme with this second one, because if individuals missed the last one, I may not be able to do another attorney themed one next month. But if you would like, I can actually send you a recording of the previous webinar that we held on incapacity and also today's webinar. You can actually view it, a recording of it online.
Oh, great. And is this attorney, David Schwartz, located in San Diego?
That's correct. Yeah. All the services that we share and experts that provide information are all held locally in San Diego. Correct.
Yeah. And actually, I was more in terms of the wills, and what I heard towards the end was very interesting. I wanted to attend, and I just couldn't get home in time to make the phone
Oh
call.
no, I'm sorry you missed it. Yeah, but again, Attorney David Schwartz is more than welcome to answer any questions you may have.
Okay.
Because again, his service is funded by the county to provide free legal consultation to older adults and family caregivers. So you're
Hmm.
welcome to give him a call.
Okay, great. And to get, like you said, just the information that was done today, do you need an email or how do I?
Yes, absolutely. Let me get your email because I still have to download today's recording. I have the previous recording. Let me just jot down your email address.
Thanks, appreciate
And
that.
let me just get, let's see here. Okay, what is your email address?
Okay, my email is Gloria, Gloria, dot
Okay,
Briggs, B as in boy, Riggs, at cox.net.
okay. So that was gloria.briggs@cox.net.
Yes, perfect.
Okay, perfect. I'll send you the files or at least links to the YouTube. We download them and save them onto YouTube, so it's easier for viewing. But
Yeah,
yeah, I should have the today's recording by before the end of the day today, or hopefully by the end. If not, I will send you both links by tomorrow at the latest.
thanks. I appreciate that so much. What was your name?
My name is Matthew. I work for the county Aging and Independent Services.
Thank you, Matthew. I just wanted to make sure
Thank
I could
you.
say
Well,
goodbye.
thank you, Gloria. I'm glad we're able to at least get some information sent to you for viewing.
Yeah,
So.
this will be interesting to listen to the whole recording.
Yeah,
Uh,
absolutely. That's why we record
okay,
it.
thanks
Okay,
again. I appreciate the
thank you.
information, the opportunity. Okay, bye now.
Sounds good. Thank you. Diane, hi. Oh, yes, thank you for your email address. So just like the previous lady, I will email you the recordings for not only last month, but this month's recording on YouTube. Again, thank you for joining us today. Okay, I have your email. Thank you, Diane. Bye-bye.